And the reason why it's so important is that if a creditor sues you, here's just some of the things that they could do with that judgment they obtained against you. They could levy on your assets and bring the sheriff in and start selling all of your personal assets. They could garnish your brokerage account or bank account. That's the easiest way to go. For most attorneys, all they need to do is if they get a judgment against you, they then file a writ of garnishment on your bank account, your brokerage account, anything that's in your own name. And then those assets will be held for your creditor. They can file a lien on your personal residence. If you have a business, they can foreclose on your business interests. So as traders, we do not want to take an account that we're looking to use for income, for retirement, to build a legacy of wealth, to pay for our child's education, and keep it in our name, because it is then being put at risk unnecessarily. And I know you might be thinking, well, I have plenty of insurance and that's going to protect me. Listen, insurance companies are not in the business of paying out on claims. I talk to people every year who tell me the same thing over and over again, that they thought they had insurance, and it turns out that they weren't covered for the claim that was brought against them. They thought they had insurance, but they didn't have enough for the amount of judgment that was awarded against them. So what you need to do then with your brokerage account is put together a structure that protects it from your creditors. And so what we do for traders is we'll typically create a limited liability company and put your brokerage account into the LLC. And the reason we like to use an LLC is that it offers protection from your personal creditors through what we call charging order protection. So you want to make sure that when you're creating this LLC, you're setting it up in a state that has strong charging order protections. And what we mean by that is that if you get sued, a creditor cannot take your LLC from you. They cannot force you to distribute your brokerage account to you. They can't force you to liquidate the company and shut it down. The only thing they can do is wait until you decide to take a distribution, which you're never going to do because you're in control of that structure. So you want to make sure that you have put yourself in a place where your brokerage account in a place, your savings account can go in there. So if something were to happen, like I just described, they cannot get after those assets. So dealing with that three-legged stool, the first leg, lawsuits, asset protection. The way you go about addressing that for your brokerage account is to use a limited liability company. I myself have an LLC that offers strong charging order protections that is set up to hold. I have 2 brokerage accounts in there and my savings account to keep them protected from my creditors.